This lecture is a brief introduction to the legal doctrines and procedures surrounding legal malpractice liability. In theory, you could have a question about this on the MPRE, so I'm going to cover the basic concepts in 2 video lectures. First, a few preliminary points. The model rules address malpractice liability only once in Rule 1.8H, which we'll review in a moment. I cover it when we do conflicts of interest. It's a rule about asking clients for malpractice waivers or settlements of potential claims. The restatement of the law governing lawyers has several sections about legal malpractice, though, and those reflect the traditional majority rules in this area. If you have a question on the bar exam or the MPRE about legal malpractice, they're probably assuming it follows the restatement rule. Remember that violating the model rules does not automatically mean a lawyer would also be liable for malpractice. There are different legal standards or elements for each of these events or phenomena in the law. So even if a lawyer is subject to discipline, like the suspension of their license or disbarment for a rule violation, they might not be subject to malpractice liability because some rule violations, like let's say practicing in a state where the lawyer is not licensed for a few months, would not create a private cause of action for a client in most cases. In addition, a malpractice plaintiff would have to show damages and causation, and they might be unable to do that even when the lawyer did something wrong. At the same time, as you might expect, violating a rule would be relevant for the question of the standard of care, even if it does not automatically result in liability. Conversely, being found liable for a legal malpractice does not automatically mean the lawyer would be subject to discipline with the bar. The state bar may have decided not to pursue a disciplinary action against this lawyer. Maybe they're short on resources. And it's possible that the state bar disciplinary authority would not think that the lawyer's negligence in handling a client matter was a serious or clear violation of a specific rule. Again, it's different rules and different legal standards. To put it another way, a trial court hearing a malpractice claim is not bound by the decision of the state bar regarding the lawyer's conduct or actions in the case, nor is the state bar bound by a court's verdict or findings about whether the lawyer should have to pay damages to the client. Of course, each one is relevant for the other and may be one factor that they consider, but disciplinary actions and malpractice are a legally distinct phenomenon, and you should be clear about that in your mind as a law student. Now, what types of lawyer mistakes give rise to malpractice claims? According to the insurers themselves, malpractice insurers, they're the ones who have to write a check when the lawyer is found liable. Conflicts of interest are by far the lawyer mistake that most often gives rise to a malpractice claim. It's also the type of mistake behind the largest malpractice claims, sometimes even in the hundreds of millions of dollars. Other mistakes can generate liability too, of course. Missing deadlines, failure to inform a client about critical legal risks, or maybe leaking confidential information about a client. But conflicts of interest problems generate probably as many malpractice claim payouts as all other types of mistakes put together. A final point. Legal malpractice claims used to be actually relatively rare, especially back in the common law era. But starting around 2012, there was a surge or explosion of huge legal malpractice claims in the wake of the global financial crises and bank failures that occurred in the 5 years before that. Even some of the large national firms faced bankruptcy because of the huge verdicts against them. And the whole landscape for legal malpractice then changed after 2012. It's gone up and down a little since then, but so far it has never returned to the pre-2012 levels that we had for generations before that. So it's fair to say we have a new normal in this area. Why does this matter? Well, for today's law students, this means that your legal employer after graduation may still be adjusting to this new normal, where there are far more malpractice lawsuits against lawyers, and the lawsuits are for much higher amounts sometimes in the millions or tens of millions of dollars. It was true when they began their careers. This has made some of the senior partners at law firms much more skittish about liability than they used to be. And this may affect how they treat new associates. Maybe someone looking over your shoulder more if you're a new lawyer, more worried about your mistakes, and they may react more severely when associates make mistakes. It's also made law firms more worried about conflicts of interest, partly out of pressure from their malpractice insurers, who are begging them to be extra diligent in their screening for conflicts because it generates so much of the liability. Now let's dive in here by doing a quick review of Rule 1.8H, which we covered in another part of the course when we discussed the conflicts of interest rules. So just to review, a lawyer shall not make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making the agreement, or to settle a claim or a potential claim for such liability with an unrepresented client or former client, unless that person is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent legal counsel in connection therewith. Now, I have a whole other video lecture explaining Rule 1.8H in detail. So let's move on now and talk about what happens when there is no preemptive settlement, no waiver, and instead the client sues the lawyer for legal malpractice. And so we're going to begin with some basic definitions. Legal malpractice is a civil tort liability for professional misconduct or negligence. Basically, a client sues the lawyer who represented them for actions that harmed the client, usually financially. Malpractice is not the same as a disciplinary action like disbarment. How are they different? Well, first of all, in most states, the malpractice action is in civil court, not a disciplinary hearing with a tribunal from the state bar. The attorney's adversary in a malpractice case is the injured person, not the state bar disciplinary authority. And the purpose is to obtain compensation for the injured party, not to punish the attorney or protect the public. Students should keep in mind that there are different types of legal malpractice. There are a few intentional torts in this area, like misusing or embezzling client funds, abuse of process, or fraud, breach of fiduciary duty, or breach of contract, and that can be implied or express. Unintentional torts, this is ordinary negligence and by far the most common type. So unintentional or negligent malpractice claims require proof of the duty of care, a breach of duty, causation, and damages, just like other tort actions and negligence. Now let's talk about negligence and the duty of care. A lawyer has a duty of care to the client, even apart from the duties under the model rules. And remember that a client may include a person that just asks the attorney for legal advice or help if the attorney knows or should know that the person will reasonably rely on the attorney to give help. This means you could have a situation where an attorney is liable for malpractice or sued for it, even though they never really agreed to represent a client. Can there be a duty of care to someone who's definitely a non-client? Sometimes. Lawyers owe some duties to, let's say, prospective clients, people who come in for an initial consultation and then the representation doesn't continue. There could be invited reliance, and depending on the area of law in the state, a breach of fiduciary duty to the beneficiaries of a transaction, like the beneficiaries of a will or a trust. What's the standard of care? Well, if you're a general practitioner, the standard of care is the skill and knowledge ordinarily possessed by lawyers under similar circumstances. This is an objective standard. On the other hand, a lawyer who purports to be a specialist or who specializes in a complex area of law, let's say corporate taxation, must exercise the skill and knowledge of most lawyers who practice that specialty. Note that lawyers statewide are going to be held to the same standards. That means that lawyers in rural areas, small town lawyers, are going to be held to the same standard as in urban areas. So a lawyer in a small rural town like Wink, Texas is expected to be as competent as a lawyer at a big town firm in Dallas or Houston. The relevant geographic area for assessing the standard of care is the entire jurisdiction, and that's usually the state or maybe the territory. Now, what happens when, as a lawyer, you just have to make a judgment call? It's a tough call, and you turn out to be wrong or mistaken. Lawyers are usually not liable for mere errors in judgment. So the question will be, would other competent lawyers have sometimes made the same decision based on the information you had at the time? Or was your error of judgment a mistake that most other lawyers would not have made? So this means that lawyers will normally not be liable when acting in good faith and honest belief that their advice and acts are well-founded and in the best interests of the client. At the same time, every lawyer is expected to know the settled principles of law. So it's not a mere error of judgment if you did not even bother to look something up or ask the client some probing questions about the situation before proceeding with the representation. Now, there's an odd procedural feature of many legal malpractice lawsuits that I call a trial within a trial. Remember that the plaintiffs in a legal malpractice action must prove damages, that is, what loss they suffered, and that the lawyer's mistake or misdeeds caused that harm. And let's say they wouldn't have lost otherwise. So if you're a litigator and then you're sued for malpractice by your litigation client, this means redoing sort of a mini version of the previous trial within the malpractice trial. You have to consider what evidence was submitted at trial supporting each side to know if the client would have lost regardless of how good their lawyer was, or what issues were presented and argued by each side, and maybe even why the lawyer in question made various strategic decisions along the way. That's why we do a trial within a trial. Proving damages is also not as simple as it may sound, because a prevailing party rarely gets everything they were hoping for out of litigation. So for plaintiffs, we can't just go by what relief they had been seeking, let's say for the case that they lost, but rather what they would likely have obtained with a competent lawyer, which is probably a more realistic amount. That means we're going to have to look at the strength of their case and evaluate what would have happened at trial. And remember that both sides in litigation have a lot of court fees and costs like hiring experts and document production along the way, so that would be discounted from the damages maybe. In addition to damages, clients bringing legal malpractice claims have to prove causation. And as we said, that the lawyer actually is responsible for things going wrong. You may have covered causation in your first year torts class, so just to review, we kind of have two types. We have actual causation, or cause, which is but-for causation. In other words, proof that the injury would not have happened but for the defendant's negligent act. We also have something called substantial factor causation, where several acts unite to cause an injury, even though any one of them alone would have been sufficient to cause it. You may have had examples in your torts class about people who started fires at two ends of the street. You may have had examples in your torts class about arsonists or negligent people who started fires, and the fires eventually converged in the middle and burnt a house down. And either one by itself would have burned the house down, but we're not going to let them off the hook just because they were lucky enough that someone else was negligent and started a fire at the same time. Or you may have had an example about two hunters that both saw something moving in the bushes and shot at it thinking it was a deer, and it was not a deer, it was a third hunter. Well, either of those hunters could have injured the third hunter by shooting at him, and they're not going to get out of liability just because there was someone else who happened to also make the same mistake. That's what we mean when we talk about substantial factor causation. It's distinct, though, from but-for causation. Moving on, a plaintiff must also prove proximate cause, that it's fair to hold the defendant liable for unexpected injuries and for expected injuries that happen in unexpected ways. When we talk about proximate cause, we look at things like how far removed was it in time, or how foreseeable was it, and were there intervening factors that contributed to the accident or to the scope of the losses. A few more points about damages. Legal malpractice plaintiffs usually seek money for their injuries. And this can take the form of direct damages, which might be basically return of legal fees they paid, or maybe they faced a default judgment. And then there could be consequential damages, damages that flow indirectly but foreseeably from the lawyer's negligence. So, for example, suppose a lawyer loses a patent or trademark case and is ordered to stop selling a certain product in a patent case. They would have to cancel supplier contracts, which can be very expensive. They may have to liquidate or maybe destroy or scrap a warehouse full of inventory that they can no longer sell on the open market. So there could be a lot of consequential costs that flow indirectly from their adverse legal result. Or let's take a trademark case. The infringer who loses may have to redo all their packaging materials and labels and marketing and advertising material, which is also very expensive, even though it flows indirectly out of losing that lawsuit. Now, this concludes the first part of our discussion about legal malpractice. In a follow-up video, we'll talk about common defenses that lawyers raise to avoid malpractice liability, as well as some basic points about the odd ways that malpractice insurance works.